McNamara. Leave for 10 minutes.
Thank you, Chair.
Let you know when there's 2 minutes left.
Yeah, I wish to agree with much of what Deputy Murphy said, including especially the condemnation of the antics of the group which parked a van outside the Rape Crisis Centre. Chairman, it is a tragedy when an expectant mother forms the belief that she cannot carry a pregnancy through to fruition to give birth to a life. The right to life is the most basic of human rights that this and every other state must vindicate. Equally, only a state with a blatant disregard for human rights, such as some kind of a warped theocracy, would seek to hold expectant mothers as prisoners of their pregnancy. The fact that for 20 years since the X case judgment, this legislature has refused to address the reality that thousands of Irish women have decided to terminate their pregnancies and travel to the UK and other jurisdictions to have this procedure, and continue to do so to this day, is an indictment of this House and our entire body politic. 83 women who received abortions in England and Wales in 2011 gave home addresses in County Clare. It's reasonable to assume many women from Clare did not give their addresses, and many others received abortions in jurisdictions other than England and Wales. In the first of 3 referenda on this issue in 1983, Article 40.3.3 of the Irish Constitution was inserted by the 8th Amendment. This reads, "The state acknowledges the right to life of the unborn and, with due regard to the equal right to life of the mother, guarantees in its laws to respect and, as far as practicable by its laws, to defend and vindicate that right." Subsequent referenda established the right to travel for the purposes of a termination and the right to receive information about such services abroad, and crucially for the purpose of this legislation, rejected a bill which removed as a grounds for the termination of pregnancy a real and substantial risk to the life of the mother by self-destruction. Such had been the finding of the Supreme Court in the X case. In that case, Mr. Justice McCarthy noted that the right to life of the girl here is a right to a life in being. The right of the unborn is to a life contingent on survival in the womb until successful delivery. And he concluded, "On the facts of the case, which are not in contest, I am wholly satisfied that a real and substantial risk that the girl might take her own life was established, and it follows that she should not be prevented from having a medical termination of pregnancy." Those are the parameters within which this House must now legislate. Both government parties agreed to examine the decision of the European Court of Human Rights in the A, B and C case in advance of the last election. Indeed, Ireland, like every other state which is a party to the Convention on Human Rights, undertakes to abide by the final judgment of the Court in any case to which it is a party. In the A, B and C case, it was affirmed that the Court does not consider that the prohibition in Ireland of abortion for health and well-being reasons exceeds the margin of appreciation accorded in that respect to the Irish state. However, the Court concluded that the Irish authorities had failed to respect the private life of the third applicant by reason of the absence of any implementing legislation or regulatory regime providing an accessible and effective procedure by which she could have established whether she qualified for a lawful abortion in Ireland in accordance with the Irish Constitution. In seeking to provide that clarity, Ceann Comhairle, our Chairman, I am concerned the protection of life during pregnancy bill, as it currently stands, may not adhere to our Constitution. While Sections 6, 7 and 8 are read in conjunction with Section 22, there appears to be no duty of care to preserve the life of the unborn as far as is practicable when carrying out necessary medical procedures in respect of a pregnant woman, and as a result, the bill may be found to be unconstitutional. I am aware that in carrying out a medical procedure referred to in Section 7, 8 or 9, a reasonable opinion must be formed, and that opinion must be formed having regard to the need to preserve human life as far as is practicable, that the risk to the life of the mother can only be averted by carrying out the medical procedure. However, while carrying out that medical procedure, it would appear that the bill as it is currently drafted would permit the intentional killing of the fetus, even if it might otherwise survive the procedure. I don't believe that to be the intention of the bill, but I also don't believe that it would be constitutional to legislate in that manner, and I look forward to clarification from the Minister on this crucial matter before this bill passes through these Houses. The last thing we need, 21 years after the X case, is for this bill to be referred to the Supreme Court and found to be unconstitutional. And it is a virtual certainty that the constitutionality of this bill will be tested, either through a reference from the President or otherwise. The second matter which I wish to raise is the Taoiseach's suggestion to the Dáil that it is not permissible under the Constitution to include in this legislation a provision for abortion in cases of fetal abnormality. However, in the case of D versus Ireland, another European Court of Human Rights case decided in June 2006, the Government of Ireland presented a very different story to the court. In that case, D, the mother of 2 children, became pregnant with twins. She was informed by her obstetrician that one fetus had stopped developing at 8 weeks gestation. In the 17th week of pregnancy, it was confirmed that the second fetus had a lethal genetic condition. She felt unable to tolerate the physical and mental toll of a further 5 months of pregnancy with one fetus dead and the other dying. She did not consider any legal proceedings in Ireland at that point, but rather made arrangements to travel to the UK for an abortion, which she underwent. She chose the medical induction option, leading to 24 hours labour, as she felt it was the option most respectful of the second fetus. She felt that there was a culture of concern in this hospital, which she found reassuring. She did not have time to remain in the UK to have counselling on the genetic implications for future pregnancies, although she was given some statistical information about the recurrence of this abnormality. She transported the fetus to Ireland for a discreet burial by a sympathetic minister. In the government's submission to the court, it stated that the fetus was viable in the X case, whereas in the present case there might be an issue as to the extent to which the state was required to guarantee the right to life of a fetus which suffered from a lethal genetic abnormality. The meaning of unborn in Article 40.3.3 had attracted some public and academic comment. However, there had been little judicial examination of the meaning unborn, and certainly no case comparable to the present. Accordingly, although it was true that Article 40.3.3 had to be understood as excluding a liberal abortion regime, the courts were nonetheless likely to interpret the provision with remorseless logic, particularly when the facts were exceptional. If, therefore, it had been established that there was no realistic prospect of the fetus being born alive, then there was at least a tenable argument which could be seriously considered by the domestic courts to the effect that the fetus was not an unborn for the purposes of Article 40.3.3, or that even if it was an unborn, its right to life was not actually engaged, as it had no prospect of life outside the womb. In the absence of a domestic decision, it was impossible to foresee that Article 40.3.3 clearly excluded an abortion in the applicant's situation in Ireland. So that was the government's submissions at the time. On the basis of these submissions, the court found that if the question of whether 40.3.3 excluded an abortion in the case of fetal abnormality was novel, it was nevertheless an arguable one with sufficient chances of success to allow the initial burden on the government to be considered satisfied. And accordingly, the European Court found that a legal constitutional remedy was in principle available to the applicant in Ireland to obtain declaratory and mandatory orders with the view to obtaining a lawful abortion in Ireland. Well, that obviously begs the question, was the government wrong in what it told the European Court of Human Rights on the 6th of September 2005, or was the Taoiseach wrong in what he told the Dáil yesterday? Thank you very much, Chairman.